Good morning and a warm welcome from Singapore to everyone who is joining us today for the annual symposium of the Singapore chapter of the International Society of Public Law, or more commonly known as ICON-S. My name is Maartje de Visser, and I work as an associate professor at the SMU School of Law. I'm also a co-chair of the ICON-S Singapore chapter.
And I am Jaclyn, Associate Professor at the NUS Faculty of Law and the Director of the Center for Asian Legal Studies. I'm the other co-chair of the ICON-S chapter in Singapore, and we will be your moderators for today.
Okay, so let me start by saying a few words about ICON-S for those of you who may not be familiar with it. The global ICON-S was officially launched in 2014, and today it has more than 1,000 active members across the globe, in all fields of law and beyond, to the humanities and the social sciences. Now, country chapters like ours aim to connect the ICON-S global network with local public law scholars, judges, and practitioners, and to connect local scholarship with global trends in public law. As part of its activities, the Singapore chapter organizes an annual symposium. And this year, we have chosen to focus on the persistent relevance of gender in public law. The idea is to identify ways in which gender has featured in the formation and implementation of law, both explicitly and implicitly, and in contestations about society. It is also to challenge some implicit assumptions about gender in law and law in gender. Hence, our wide-ranging and hopefully somewhat provocative topic today is ungendering public law in Asia.
And indeed, this is really more than a timely topic because gender and the law's treatment of it has been in the limelight across the world in recent years. Not just the Me Too movement, which is a principal catalyst for this discussion about gender, power imbalance, and abusive behavior, but the Me Too movement really was only a tipping point. The issues that it brought to the surface have been percolating among scholars and advocates for many years now. And beyond issues of power and abuse, the obstacles that women continue to face in the workplace, in what is sometimes encapsulated in the term glass ceiling, are also under intense scrutiny. Within the law, we see that growing attention is being devoted by academics and policymakers to the need for constitutional recognition of gender equality. But despite the fact that the Convention on the Elimination of All Forms of Discrimination Against Women, or CEDAW as it's more commonly known, is one of the most widely ratified international conventions, and many Asian states are signatories. But the reality is that discriminatory practices persist. And litigation is one obvious strategy to challenge such practices. And this is the focus of some of our speakers' talk today, where they will recount how gender equality has been emerged in constitutional cases in Asia.
Now, at the same time, it should be pointed out that gender equality is not merely a woman question. Society and the economy at large stand to benefit a great deal when women are lifted up. So a 2018 report by McKinsey found that advancing women's equality in the Asia Pacific could increase the collective annual GDP by 12% as compared to the status quo. Unfortunately, however, findings by the World Economic Forum suggest that we still have a long way to go. Its 2020 Global Gender Gap Report found that realizing gender parity in South Asia will take 71.5 years and an incredible 161 years in East Asia and the Pacific region. Now, a critical hurdle in this regard are pervasive socio-cultural preconceptions regarding the proper role and behavior of women. Several Asian societies have strong patriarchal cultures, limiting the extent to which women are able to effectively participate in decision-making. Religious practices too may curb the freedom of action that women possess. Now, this reality gives rise to challenging questions about how the law can assist in eradicating harmful stereotypes or otherwise empower women to call out discriminatory practices. Now, for this to happen, parliaments, governments, and the courts must be willing to intervene and make the adoption of gender equal laws and policies a matter of priority. Several of our speakers will discuss how the law has dealt with social preconceptions, as well as the political representation of women in Asian democracies.
Within Singapore, we are also seeing increasing attention being directed at gender equality issues by legal and political elites. Just last month, the Law Society released a report on gender diversity in the Singapore legal profession, which highlights some issues in recruitment, retention, and career progression, as well as gaps in mentoring and flexible work arrangements, which disproportionately affect female lawyers. And just over the weekend, the Singapore government announced that it is going to embark on a wide-ranging review of gender issues in Singapore, which would culminate in a white paper. And so today's symposium is really riding a big wave on gender issues.
So on that basis, we are more than pleased to introduce to you a stellar lineup for today's event. All of our speakers are well known for their work on public law and gender issues. Among them, they canvass a diverse range of areas in which gender issues arise, from criminal law to political representation to health. And they've done so with the help of a diverse range of approaches, from socio-legal studies to jurisprudence to law and film. So by bringing them together, we know that this will make for a stimulating and informative symposium. So our 6 speakers are, in the order in which they will be speaking, Rosalind Dixon, Wen-Chen Chang, Dipika Jain, V.Cheah, Marco Wan, and Devin Joshi. Now, before we get going with the lineup and the symposium proper, a few housekeeping points. Each of our 6 panelists will speak for around 10 minutes, ensuring that there will be ample time for an interactive Q&A session. You can enter your questions using the Q&A function that you find at the bottom of your screen. You may do so anytime, during or immediately after each presentation. We ask that you please identify yourself and state to whom the question is addressed, whether it is to a specific speaker or to the entire panel. Now, in order to have a more orderly Q&A, the panelists will only address your questions at the end, after all of them have finished their initial remarks. Please note that we may bundle question or change the order of the questions. Now, lastly, this symposium uses the Zoom webinar format for a more effective experience, and it's being recorded. Now, let us, without further ado, introduce the first speaker. She is Rosalind Dixon, Professor of Law at the University of New South Wales, Australia. Ros is a well-known voice in comparative constitutional law and currently the co-president of ICONS Global. She will start us off with a conceptual framework on different modes of conceptualizing the aims of gender justice, which she categorizes as ameliorative, transformative, and disruptive justice. So Ros, the floor is yours.
Thank you very much, Maartje and Jaclyn, for the opportunity to be part of this forum. Let me start in my ICONS capacity and congratulate you on once again bringing together a wonderful lineup of public law scholars from across the region and working with your home institutions. My thanks and congratulations to NUS and SMU for their continued role in fostering such an interdisciplinary and broad public law community in Singapore and beyond in the region. As co-president, I'm enormously grateful for the support of those faculties and to Maartje and Jaclyn for their leadership in continuing to build a very strong regional presence in what is a truly global society. So thank you and congratulations. First off, my remarks today will draw on some of my prior research on how we should understand the goals of gender justice when we think about public law. I want to talk about 6 feminisms and 3 modes of understanding our goals, as Maartje outlined. I then want to say something a little bit distinctive about Asia and how we understand those modes in Asia. And lastly, something about public law as a mode of responding to these challenges. So the first thing is about what do we mean by gender justice? And like Maartje, I think it's incredibly important that we take seriously the pluralism within ideas about gender and sexuality, both in regards to gender identity, that we no longer live, if we ever did, in a binary world, that we take seriously transgender ideas and identities, that we take seriously the connection between gender and sexuality, and the very different experiences of those women who live lives that are impacted by race, ethnicity, religion, disability, sexuality in their lived experience of dignity and equality. So many of you will be familiar with a range of scholarly ideas about feminism, and particularly liberal, cultural, and dominance feminism. These are some of the most important and most famous ideas developed through the 60s through about the 90s in the United States and elsewhere about how we should understand feminist ideals. I'm going to say a little bit about each of them. But the last 20 years has seen a proliferation of understandings which might be labelled agency feminist, post-structural, postmodern, and intersectional. And I want to suggest that as we talk about gender, it's really important that we keep in mind both the insights of liberal cultural dominance feminism and the more complicated, complexifying, contextualizing insights of agency, post-structural, postmodern, and intersectional feminism. The way in which I suggest we ultimately do that is through these three concepts that I am going to explain in more detail. But let me start by suggesting a little bit about each of those six feminisms and what they have to contribute. Liberal feminism starts with the idea that the fundamental problem for gender justice is a denial of equality of opportunity, that we stereotype people and make generalizations about their preferences and their capacities, which fundamentally undermine equality of opportunity. Now, equality of opportunity can be understood formally or substantively. Not everyone has the opportunity to walk up the stairs. Substantive equality of opportunity requires a ramp for those who are not able to walk up a ramp. So it doesn't have to be a thin formal understanding, but liberal understandings remain committed to equality of opportunity and to eliminating forms of stereotyping about preferences and abilities that would impair or undermine that. Clearly, the fact that it's the first feminism, if you like, doesn't mean that we've moved beyond it. Equality of opportunity remains at the heart of what much of our debate is ultimately about. That's what we care about in many, many cases. So it's the first and it's an enduring concern. Cultural feminism is in some ways in tension with some of the claims of liberal feminism about not stereotyping women's preferences and abilities. Because one of the bugbears of liberal feminists is the assumption that women may prefer to devote time and energy to being in the home. Whereas cultural feminists come at this from a completely different angle and say that there are two broad modes of being in the world. Let's call one M, let's call one F. You could call them A and B. One is extroverted, individualistic, productive. The other is more introverted, relational, and reproductive. One way of being is about being in the market. The other is about care and being in the home. And the claim that cultural feminists make is that we have tended systematically to downgrade the importance of F or B type activities and values. We reward masculine behaviour and M activity. We reward market activity and aggressive individualism over collaboration, relation, and care. And they seek to revalue all those modes of being that might be associated with F. Now, I've given what I regard to be a more sophisticated rendition of cultural feminism than some of its key proponents, who sometimes fall into a kind of biological essentialism, where they equate women with caring or with F values in ways that are readily critiqued and problematic. The cultural feminism at its best is trying to encourage us in the service of gender justice to revalue all of those activities for their own sake, but also because they tend to be overperformed by female identifying individuals, and therefore by revaluing care, we revalue women's contribution. The third feminist argument that came out of the first wave of key feminist ideas is dominance feminism. The idea that what is the problem in gender equality, inequality rather, is structural hierarchy, subordination, dominance, and that following on the work of Karl Marx, but transferring class to sex, we come to understand that the key challenge is not an individualized one, but a structural group one, which is to stop a situation in which men are a dominant class as compared to women. You can see the problems of that from a more gender fluid perspective, but the key insight is that there are group-based structures of subordination, hierarchy, and domination. Catherine McKinnon and Andrea Dworkin, to a lesser extent, were the key proponents of this idea, and they relied on sexual violence as the key analytic framework for understanding the ways in which sexual hierarchy domination is perpetuated and reproduced. Eliminating sexual violence was therefore the original act of feminist politics for them and a means for achieving gender justice. Enter the second wave of feminist thought. Agency feminists push back against the dominant feminist assumption that we are fundamentally shaped by hierarchy and subordination. They acknowledged limited agency, but they wanted to emphasize that women still make choices and those choices are valuable for women's autonomy and dignity, that we need to design policy structures and public law institutions to emphasize and encourage agency rather than assume its absence. That can also have a sex positive character to it in understandings around the regulation of sexual activity. Then you have postmodern, post-structural feminism, which is closest in those six feminisms to queer theory. It says that gender itself is inherently constructed by language, by ideas, by law. And the aims of post-structural postmodernists is to challenge gender binaries and their relationships to structures of heteronormativity with a view to freeing us all from the constraints that those categories impose. And finally, you have intersectional feminists who argue that race, in particular in the US and elsewhere, but also ethnicity, religion, disability, age, class, and other characteristics fundamentally shape our experience of gender. And none of these other accounts make sense unless they are put together with an account of those other sources of injustice. This is a rich set of understandings which we can massively draw on and benefit from, but the problem they pose for us as scholars is they're very, very rich and diverse, and often they disagree with each other in ways that can be paralyzing. When you sit down to write about gender and the first 10 pages have to be a kind of throat-clearing exercise, one really gets very little scope on pages 11 and 12 to say what one really wants to say. And so one of the things I have tried to do in past work is to draw on comparative case law and inductive processes, looking at those cases and mapping them back onto these six feminisms to think about what our key areas of agreement and disagreement are. Not to simply bracket disagreement or be what is often called strategically essentialist, because fundamentally those approaches do not take seriously the insights of the second wave of feminism. But to say that as feminists, we are committed to some range of goals that might be understood as ameliorative, disruptive, and transformative. So cultural feminists want to improve the degree to which we value care. Intersectional feminists want to improve the lived experiences of women who intersectionally experience gender, race, and class disadvantage. But not all feminists have an ameliorative focus. Some reject it in favour of disruption. So post-structural, postmodern feminists, for instance, would rather explode gender as we know it than improve the lived experience of those existing categories and those in them. So disruption is a key part of the postmodern, post-structural agenda, but it also has resonances with liberal feminism. What do liberal feminists want to do? Disrupt stereotypical thinking, disrupt patterns and assumption about patterns and preferences. So the liberals and the post-structural postmoderns find common cause in this kind of framework, even while historically and conceptually they are often very far apart. And finally, there are feminist understandings that are more thoroughly transformative, that can set out what it would look like to imagine a world in which we actually have achieved gender justice. And in that respect, cultural feminists and dominance feminists, who normally hate each other and fight all the time, again, can find common cause. What do dominance feminists want? A world where gender-based hierarchy is eliminated, and especially the forms of sexual violence that create and perpetuate that hierarchy. What do cultural feminists want? They want a world in which M and F are valued equally, and M and F tasks are distributed in ways across individuals and households that allow for that possibility. This is not to say all six agree on all three, not at all. It's to say those three categories provide us a non-essentialist way of understanding and talking about gender justice that acknowledges pluralism in an appropriate way, but allows us to move forward in discussing specific issues in ways that locate our ideas and our politics in ways that are intelligible to those who disagree with us, and allow us to conceptually stake out where we are coming from. So I offer it as a frame and a beginning point of this discussion in the hope it might be useful. But let me say two more brief things before I turn over. One is about Asia and one is about public law. One of the challenges, I think, about those three discourses in Asia is that a discursive disruption sits in some ways in tension with Asian constitutional commitments to stability. That the Asian distinctive challenge here are some of those that Maartje mentioned, about patriarchy and tradition, but some of it comes from a deeply felt commitment to stability as a value. And therefore, any version of disruption, whether it be liberal or post-structural, post-modern, has to grapple quite directly in Asia, I think, with a very valid and important Asian constitutional tradition which values and prioritises stability over radical transformation through a disruptive mode. I don't think that that means, however, that these modes are inapplicable in Asia. If anything, I think it suggests that transformative discourses which set out a clear goal might have greater appeal. So, for instance, articulating a vision of a world in which there is a true valuing of M&F values and activities and a sharing of those across genders, and articulating the idea that we wish to eliminate sexual violence and hierarchies that flow from it, in my view, might actually be more appealing to Asian governments than discourses that draw on disruptive, postmodern, post-structural liberal ideas that throw out existing categories without first offering an alternative vision of where we may be travelling and heading. And the good news is that the discourse of transformative constitutionalism, which originated in some combination of South Africa and the United States Academy, has come to Asia. The Indian Supreme Court is at the forefront of that, and I think other courts are beginning to grapple with that idea in ways that would lend credibility in Asia to the idea of transformative feminist constitutionalism. But the last thing I want to say is that public law itself needs to re-examine itself if it is to achieve true gender justice. Much of the current challenges of gender inequality lie in the economic sphere as well as in relation to violence and the home. And these are not spheres that public law has traditionally reached. So my own view is that as public lawyers, our challenge is to take on these ideas, these very clear feminist inspirations, challenges, and sort of pathways for change, but to interrogate the boundaries of public law and to force ourselves to bring public law values into the design of workplace policies, childcare policies, policies that aren't the traditional purview of public law. And rather than thinking of that as necessarily a challenge of judicial review or as a quasi-public institutional design question, it's really about bringing public law values into core policy design areas as much as it is about traditional public law. So I think that the challenge of ungendering public law in Asia could not be more important, but it requires us, one, to understand ungendering as consisting in amelioration and transformation as well as disruption. Two, to understand that that is particular to the Asian tradition and its value on stability. And three, as public lawyers globally as well as in Asia, to interrogate deeply what we think of as the boundaries of our field in order to push our field into new and challenging enclaves of inequality, which are often domestic and economic, and where very much the challenge for liberalism, this was the debate, if you recall, between John Rawls and scholars such as Susan Moller-Okins, to take liberalism into the home and the economic sphere so that we can really deliver on those goals. Some of my own work has recently been in that vein. I have tried to think about economic policies through what I call a democratic liberal lens in order to take public law values into economic policy so that it can benefit women, or create a more pink democratic liberal model. But I'd be happy to take questions on those specific ideas. My time is more than up, and so I thank you for the opportunity and look forward to hearing from colleagues about their more specific ideas about how we think about this challenge in Asia.
Fantastic, Ross. That was thoroughly enjoyable. And as always, you've helpfully charted the way forward and the challenges that all of us must face. Now, our next speaker is Wen-Chen Chang. She is a professor of law at the National Taiwan University. She also holds a concurrent appointment as professor and dean at the National Chiao University in Taiwan. As a leading scholar on comparative constitutional law in Asia, Wen-Chen will reflect on the wider regional impact of two constitutional cases in Taiwan, highlighting the role of social movements, or lack thereof, in advancing constitutional litigation on gender issues. Wen-Chen, we look forward to hearing from you.
So thank you for invitation to speak on this roundtable. And also thanks for Jaclyn and Maartje for hosting once again. This, I think, is the second I.Opening chapter in Singapore. And I have been honored to join twice. Okay, so in the interest of time, I will move very quickly to my point today. I think, like Ross has just pointed out, gender is very much social, political, economic, and contextualized. So that's on the one hand. But on the other hand, sex and gender equality dynamics also are to be worked with any existing legal and constitutional framework. So we see the dynamics between, on the one hand, sex and gender equality dynamics in the society. On the other hand, sex and gender equality and dynamics to be at work with legal and constitutional framework. So I would like to touch upon this paradoxical relationship between, on the one hand, sex and gender in society, and on the other hand, the legal constitutional framework, by pointing to two recent constitutional court decisions in Taiwan in relation to sex and gender. One is now the very famous same-sex marriage case decided in 2017 in Taiwan. The other is really very recent this year about the criminal adultery case decided in Taiwan. To give more details for our audience, allow me to share the screen for now. Now you can see I made just simple comparisons between these two cases. So in the same-sex marriage case, you can see the petitioners are from a gay man, but he was and has been assisted by a group of lawyers and activists promoting equal marriage rights, and also in particular for gay rights movement. And then there was also a petition from Taipei city government that intended to give equal marriage license to same-sex couples. And this case was really grounded on years and decades of social movements for gay rights, and also for, in particular, same-sex marriage for gay and lesbians. And it was highly controversial. And then the court, in order to decide on these cases, they held oral hearing. And between the time of oral hearing and the time that the court finally released the decision, there were daily protests in the front of the judicial building by both pro and anti-gay marriage camps. In other words, this case was very much surrounded all the social movements, political dialogues, and so on and so forth. In the end, the court decided that non-recognition of same-sex marriage was unconstitutional, but also recognizing this big social discussion, this big social controversy, they gave a 2-year deadline for the legislature to implement the decision. Despite that decision, before the deadline, well, there were a lot of discussions, a lot of, I will use even unrest to challenge that decision. So there was many proposals for public referendum by pro and anti camps, again in 2018, a year after the decision. But nevertheless, the law to implement that very decision was finally passed before the deadline, actually right on the day at which the court demanded. So this is the same-sex marriage case. As you can see, it's very much grounded in the context where the society is at tension with the court. Court has been responding to the society. Now, let me introduce to you the most recent case decided by Taiwanese Constitutional Court, the adultery case this year. So the petitioners for this case are very special, okay? They are 16 judges who presided over adultery cases. So they decided to suspend their proceeding and petition to the Constitutional Court alongside 6 individuals. In the very beginning, it was really only these 16 judges alongside 2 individual petitioners. So you can see, unlike same-sex marriage case, the petitioners for adultery case were very much judges, judicial elites, and there were not much social discussions before the case entered into the court. And not to mention, there were no protests at all when the court held the oral hearings and between the time of the oral hearing and the final release of the decision. So by and large, the society was quiet a bit. And then eventually the court held that criminalization of adultery was unconstitutional and in violation of sexual self-determination. And the provision in the criminal code was ordered to lose effect immediately. So because of this very strong decision, so the media, the society, many stakeholders were really awakened in the way by the decision. So the oral hearing, when the court decided to take the case and held the oral hearing, the society was not, in the sense, awakened or put into discussion. But when the court decided to immediately invalidate the provision, then the society was really awakened by the court. So if you look at these 2 decisions, you can find that same-sex marriage case is pretty much a case grounded on decades of social movements as well as political struggles. In particular, when the court decided to order legislature to implement same-sex marriage in 2 years, that really put pressure on the political process. So legislatures were really called upon to work on this particular issue. Before that, legislature, politicians, political parties, they were really afraid of facing up this issue. And also, same-sex marriage issue itself is, and I would say, still now heatedly debated. There's really no social consensus on this. So this is a clear case when the courts acted quite far ahead of society. And even after the decision, the court still facing, and I think the society in general, still facing strong social resistance. But on the other hand, if you look at the criminalization of adultery case, as I said, so all the petitioners were from young judges presiding over the cases at the district court. So they not shy away at all, putting forward their arguments to argue that this provision was in violation of privacy and sexual autonomy. But there was really no social movements behind this petition or behind this demand. Well, admittedly, there's been always discussions about decriminalization of adultery. Right? There's always been the discussion, and there's always been the debate. And yet, there wasn't any consensus before the court's decision that, well, the society or the majority or even the women groups would now feel and strongly support decriminalization of adultery. So in fact, women groups were divided on this issue. So when the court held the oral hearing, I was, again, in both cases, I was called upon by the court as an expert to give constitutional opinions. But then the court also invited representatives of the social groups. In criminalization of adultery case, you see some women groups were invited as continue to support criminalization of adultery. And then there are also other women groups then arguing for decriminalization of adultery. So you see women groups are divided. And again, I think this is, again, a decision that is ahead of society. And ironically, as I said, so this petition was made by a group of young judges, and the court decided clearly that the provision was in violation of a constitution without general social support. Nevertheless, once this decision is done, it's facing far less social resistance. Unlike the same-sex marriage, you see the huge social movements on both sides, indeed. But you see the society is at tension and at work with the discussion. So these certainly pose two very different models, right? So if we consider sex and gender equality and dynamics is very much social, political, and contextualized. And on the other hand, we know they must also working with the existing legal and constitutional framework. Then you see two models here, right? One is populist model or social model. The other is elitist model. Right? And surprisingly, we may find the elitist mode, right? The elitist model is asserting, is giving much more effects in terms of advancing sex and gender equality for now, right? But we don't know if there will be setbacks or firing back on this elitist model or on this other more social-based, popular-based model. But this is quite contrasting in the sense we see in recent years in Taiwan with this sex and gender equality dynamics discussions and judicial responses. You see already two very distinctive models coming on the table. Last, I want to also discuss about some sort of transnational regional impacts, as Russ suggested, right? So sex and gender equality and dynamics may develop a different distinctive model in Asia, right? And so now we see in Taiwan, so there are two different kinds of constitution model, right? One is very much based on social movements. The other is very much based on judicial elite. And how about these implications to the region, right? Should, in other countries, judges take a more lead on these assertions, or should judges wait? And are the courts being influenced one another? So I want to also point out South Korea and Taiwan in both same-sex marriage and criminalization of adultery case. So in South Korea, and in both cases, South Korea Constitutional Court decided the cases before Taiwanese Constitutional Court. So in same-sex marriage case, South Korea Constitutional Court was facing this case in 2016. they decided to dismiss it. So they didn't take on the case. And they argue it's a matter for the legislature. And you already learned that in 2017, the Taiwanese Constitutional Court decided to take on this case. They are not entirely saying this is not a matter of legislature. If you recall, they decided to give a 2-year time for the legislature to implement this same-sex marriage recognition. But in both cases, neither was referred to each other. In criminalization of adultery case, right? In South Korea, again, so the case was decided in 2015. There, the court decided to rule criminalization of adultery was in violation of privacy and sexual self-determination. In Taiwan, 5 years later, you see our court decided that was also in violation of sexual self-determination. Again, the Taiwanese court did not refer expressly, explicitly to the South Korea Constitutional Court. But I think both courts and a particular Taiwanese court and judges are very aware of these decisions in other courts. So the dialogues were not really expressly formed or formulated, but you see these different timings of court decisions and to some extent certain inferences between the courts. And whether this is a result of judicial elite and among them their dialogues, or this is the result of activists, you know, all these women groups and same-sex marriage supporters, you know, they are trying to also enlarge and engage in these dialogues, remains open. But you do see some regional, or I would say one decision in this other country, the other in this other country, and then more and more on a regional and transnational scale. And then to what extent this would facilitate the kind of model of judicial elitist model for pushing, promoting sex and gender equality, or you will have to wait for a more social, wider base for sex and gender equality. So that's will be my contribution for today's roundtable. Thank you.
Thank you very much, Wen-Chen, for this explanation of quite daring judicial behavior with the courts pushing ahead of the population. Now, our next speaker is Dipika Jain. She is a professor and vice dean and executive director of the Center for Health Law, Ethics and Technology at Jindal Global Law School. Her research focuses on law and marginalization, and she has been an active voice in gender and sexuality rights in India. Today, she will be speaking about the constitutional recognition of reproductive rights and its limitations in the context of India. Dipika, please.
Thank you so much, Maartje, and thank you, Jaclyn, for having me here. It is my honor to be on this panel and speaking today. So let me start by talking about Catherine Young. In her book called Public Law of Gender, in her introduction, she argues that out of 194 written constitutions around the world, almost all guarantee equality in express terms. Almost 2/3 entrench equality or non-discrimination guarantees on the basis of sex, and 1/3 on the basis of gender. Half of the world's constitution recognizes gender equality, started recognizing gender equality after CEDAW was adopted. Now, India adopted its constitution 3 years after its independence in 1950. And the post-colonial Indian constitution recognized gender equality as a fundamental right then. Right? And recently in 2017, in a landmark case called the Puttaswamy case, a 9-bench decision, which was a case on privacy rights, the plurality opinion and also the other judges recognized abortion and reproductive rights as a fundamental right, but within the framework of life, personal liberty, and privacy, and not equality. So I'm going to outline why it is important for the Supreme Court or the jurisprudence to recognize abortion within the equality framework, and why the privacy framework is insufficient for marginalized persons' access to abortion in the Indian context. So public law has a long history of supporting legalized subordination of women and minorities, we know that. Now, abortion in India is criminalized under section 312 to 316 of Indian Penal Code 1860, which is the colonial legislation. In 1971, the government of India decided to enact an enabling legislation, which was the Medical Termination of Pregnancies Act, but it was an exception to the criminalization. It wasn't an enabling rights-based legislation. And the exception was granted, exception was given to the medical provider to exempt them of their criminal liability in performing the abortion. So under the 312 IPC, the woman who undertakes abortion with her consent and the doctor who performs the abortion, both were liable to be criminally prosecuted for from 3 to 7 years. Now, this is the exemption that is granted to the medical practitioner if they decide to conduct the abortion based on certain qualifications. So it's not a right in India, it's a qualified right. And only some people can access abortion. So for example, only married women can access abortion. And if you're a unmarried woman, you can access abortion if you're raped or if there is fetal abnormality. And in case of danger to a woman's life, then of course you can get an abortion. And the limitation is up to 20 weeks gestation period. And medical provider authorization is mandatory. So the woman is not at the center of the law at all. So that's how the law is. Recently, just before the lockdown and the pandemic, there was a reform bill introduced to this amendment, to this legislation called the MTP Bill 2020, which actually continues the rationale, the eugenics and the patriarchal rationale, and again fails to center the woman at the center of abortion reforms, but allows, for example, unmarried women to sort of get abortion and increases the gestation limit from 20 to 24 weeks. But again, is framed within the eugenics rationale, where if there is fetal abnormality, you can get an abortion without a gestational limit. Now, having had that background of legislative framework, which is extremely limiting for access to abortion for women, we have a very progressive Supreme Court sort of jurisprudence from 2009 onwards. So if you were to track the cases from 2009 onwards, there is some kind of linear progression and recognition of reproductive rights. And the recognition of reproductive rights have happened within the clause of Article 21 of the Constitution of India, which is personal liberty and privacy. And it is not within Article 14, 15, or 16, which is equality. And here is where I have certain concerns, which I want to outline. So, for example, in the 2017 9-bench decision in Puttaswamy, the Supreme Court reaffirms the recognition of reproductive rights and frames women's intimate personal choices as falling within the realm of decisional privacy. And we know that from much of this conversation around privacy rights that there are feminist legal theorists and critiques that have repeatedly highlighted the limits of privacy in terms of achieving reproductive autonomy in particular. This is because privacy is understood as a negative right, which makes the guarantee of affirmative state measures highly unlikely. Now, in this 9-bench decision, there was a decision which was authored by Justice Chandrachud on behalf of 4 other judges and himself. And he wrote the decision, and that is a decision that I read very closely because this decision responds to the feminist critique and recognizes the historic power that privacy has played in obstructing women's rights and cautions that the right should not be used to allow gender-based violence or further confinement of women to domestic sphere. Justice Chandrachud's engagement with feminist critique imposes positive obligation on the state to ensure that women are given meaningful choices. So while this decision recognizes reproductive rights and right to abortion within privacy, dignity, and health framework, it fails to articulate gender equality framework or non-discrimination framework. And now I will look at why that is important and why there are limitations of privacy right, even though there is response to the feminist critique, which is mostly emerging from the US feminist critique and the judgment on Roe versus Wade. Reproductive justice activists have emphasized that a focus on location of a right to abortion within a right to privacy does not adequately address oppression on multiple axes. The right to choose needs a host of other conditions for its realization, which is also articulated by Rose earlier in her presentation. As a long-term strategy, the recognition of liberal private right does not sufficiently address structural inequalities that prevent individuals from exercising their rights. These rights claims treat groups as homogeneous, assuming, for instance, that all women access all cultures and classes are the same. something that is disastrous for reproductive rights in a country like India, fraught with class and caste hierarchies that directly affect access to healthcare services. For example, Dalit and Adivasi women, which are the indigenous women in India, face multiple discriminations owing to the degrees to which caste is embedded in public healthcare systems. This is illustrated by a case in 2016. This is the case of an indigenous girl, Amita Khujur, who was a young girl who was a rape survivor. And she wanted to terminate her pregnancy, and she discovered her pregnancy at 12 weeks. She approached the hospital for her termination. At that point, the hospital asked her for first information report of a rape, which was not registered by the police official. Thereafter, she was sent to a second hospital. When she went to the second hospital, they again refused to register her case and asked her to go back to the police station. At this point, she petitioned the court. And there's a human rights organization in the country that sort of represented her in the court. And at that point, she became 21 weeks. So there was a lapse of 9 to 10 weeks because of structural barriers. She goes to the court and she's now beyond the legal limitation of abortion in India, which is 21 weeks. Fortunately, in this case, the court grants her the termination and allows for the termination to happen. However, this case demonstrates the range of social and legal issues that impede access to healthcare services for marginalized people. And we know that from a very closer reading of these cases from various high courts, that there are very different standards of giving judicial authorization to these cases, and you may not always actually get a positive notification from the court. So the second point is that while Justice Chandrachud actually articulates these very robust privacy framework, there are other judges which actually state very clearly that privacy is not absolute. In fact, one of the judges says that invasion of privacy in the presence of compelling ground of public interest can be compromised, which is exactly how Roe versus Wade is framed, right? And those are some of the biggest concerns that many reproductive rights activists have had in the US context. So, and then there was a decision in 2019 called Sinha versus State of UP, which explicitly recognized that privacy in India is not an absolute right. It's not an enumerated right in the constitution. It's a judicially recognized right. And second, it's not absolute. So I think these things make privacy extremely fragile to sort of have a reproductive rights framework. Now, legal recognition of women's reproductive rights is insufficient without adequate state and social structures to provide women with practical ability to access these rights and exercise this freedom. Now, an equality-based approach looks at both formal and substantive equality. Addressing gender equality requires a keen historic and social understanding of centuries of gender inequality, discrimination and stereotypes, requiring states to fight against discrimination on several axes, especially for the most marginalized groups. Now, in 2018, there were two other landmark decisions. The first one was Nafte Johar, which led to the decriminalization of same-sex relationship between consenting adults. And the second was called the Joseph Shine, which was decriminalization of adultery. And these two judgments were also given by the same judge. They were 5-bench judgment, but Justice Chandrachud was common within these three judgments. So I again look at his opinion very closely. And in his opinion, again, he recognizes both these rights within equality framework. And I read this equality framework very closely. Now, the Supreme Court recognizes that any criminalization of a subgroup adversely affects access to healthcare services for that group and is inappropriate because it seeks to regulate non-procreative sexual conduct for that group. Therefore, it was recognized by the court that the Constitution protects human sexuality, which the state cannot regulate in the form of rigid, marital, and procreative sex. So exactly this becomes the rationale, the premise for arguing that criminalization of abortion creates barrier to healthcare for pregnant individuals, further restricting their ability to have non-procreative sex. So it looks at access to abortion, but it also looks at sexuality rights connected with abortion, which with the privacy framework absolutely fails to do. So these decisions indicate that the right to non-discrimination on the basis of sex and gender create an obligation on the state to eliminate laws that serve as barriers to healthcare and are reflective of gender stereotype. A structural understanding of discrimination would allow for transgender, intersex, and gender diverse persons, for example, to be included within reproductive right frameworks. So I'd like to conclude by saying that these judgments have allowed for articulation of reproductive rights and that reject the essentialization of gender and naturalization of gender difference. And I think that's a more productive way to think about reproductive rights. then to think about privacy. And of course, there is also a critique of equality. But if there was going to be a constitutional revolution, it would have to be within equality rights. And of course, the structural critique of constitution and equality is also there. And I also discussed that, but I don't have time to take on that right now, but I do discuss that in my paper. Thank you.
Thank you, Dipika. That was a brilliant differentiation of the different frameworks in which gender equality can be advanced, the difference between privacy and equality. And I think it's also really interesting because it points to the three presentations we've had so far points to, I think, something very important, which is the context in which gender equality is being pursued. The contextualization do not just point to what is possible, what kind of transformative discourse is possible, but also to what is most pressing. And the different identities, the intersectionality that comes through in these contexts. So for our next speaker, we have Ling, currently Assistant Professor of Law at the National University of Singapore, and she brings with her a wealth of experience in academia and practice to her work on criminal law. Prior to joining academia, Ling worked as a legal officer at Interpol's Office of Legal Affairs, and was a visiting professional at the International Criminal Court. And today she will be speaking on her research on gender stereotypes in criminal law, specifically on how gender features in provocation cases across Singapore, Malaysia, and India. Ling, on to you.
Hi, good morning. Thank you, Jaclyn, for that very kind introduction. Thank you, Jaclyn and Maartje, for inviting me to this important roundtable. I'm really excited to share my research, and I look forward to getting your feedback. So in my larger paper, which will be coming out in Human Rights Quarterly next year, I actually examine how gender stereotypes impact criminal law adjudication, specifically provocation case law in India, Malaysia, and Singapore. Despite CEDAW's recognition, CEDAW Convention Against Discrimination of Women, recognition that state actors, including courts, have a duty not only to avoid applying stereotypes, but also to transform and eradicate them. So in this, on this point, my talk actually builds on Rose's talk on transformative approach to gender justice, and also on Dipika's talk on the role of courts. For the purposes of this talk, because I'm conscious that I have limited time, I will focus largely on Singapore examples. And I will argue that not only do courts have a duty to reject gender stereotypes, but what do courts have to do in order to transform them? So before I start, I will just show an outline of my talk. So I will first highlight how CEDAW, in particular Article 5, and its transformative approach to equality, requires all state actors, including courts, to avoid relying on gender stereotypes and work towards their modification and elimination. And the questions that I specifically will seek to answer through my inductive study of case law is, how do gender stereotypes continue to impact criminal law adjudication in these three countries? And what does transforming or modifying gender stereotypes, what does this mean for courts? I will demonstrate how gender stereotypes continue to shape judicial decisions in terms of fact-finding, formulation of legal standards, and very importantly for the Singapore cases, judicial language. And apart from not relying on gender stereotypes, I will argue that based on CEDAW's approach to gender justice, courts should strive to name and critique gender stereotypes, represent women in a dignified and respectful manner, and exercise their interpretive discretion to contribute to the eradication of gender stereotypes. So I've chosen to focus on these three countries because they have very similar penal codes in terms of the wording and history, due to as they were all colonies, former colonies of the British Empire, which transplanted the code from India to Singapore and Malaysia. All three have ratified CEDAW and are generally committed to equal treatment in constitutions. CEDAW's, what is interesting about CEDAW and that's least discussed is Article 5, which is really important when it comes to gender stereotypes. Article 5 states that state actors are to modify the social and cultural patterns of conduct of men and women with a view to achieving the elimination of prejudices and customary and all other practices which are based on the idea of the inferiority or the superiority of either of the sexes, or on stereotyped roles for men and women. So there are the emerging scholarship on the need to give this, apart from refraining, apart from not relying on gender stereotypes, what does this obligation of transforming gender stereotypes mean for courts? So there's been quite a lot of discussion on what this means for executive actors, for parliamentary actors, legislative actors, but what does this mean for courts? And there's been a group of scholars that argue that at the very least, courts should be required to name and critique these gender stereotypes. Based on my inductive research of case law, I argue that not only do courts have to name and critique gender stereotypes that they come across in their cases, they have to go further. They have to ensure that they represent women in their decisions in a respectful and dignified manner. And they also have to exercise their interpretive discretion to work towards the modification of harmful gender stereotypes. So first, I will discuss how courts continue to rely on gender stereotypes in decisions, focusing on Singapore cases. Then I will argue, referring to several cases, how to fulfill the transformative obligations under CEDAW, courts really have to go further to transform these gender stereotypes, not just not rely on them. So gender stereotypes can impact judicial fact-finding in several ways as due to the assumptions generated. This was not so much of a problem in the provocation cases in Singapore. So my study focused only on provocation cases. I'll probably be looking at other types of crimes in the future, but for the provocations cases that I looked at, the more problematic cases came from India, where courts, especially lower courts, had a tendency to presume that any act of adultery or suspicion of adultery or unfaithfulness on the part of the woman would automatically lead to a loss of self-control and fulfill part of the provocation test. So the minute that there is suspicion of adultery or any facts related to unfaithfulness, the courts would just assume that the accused person must have lost control, and instead of really examining the facts of the case. In Singapore's context, what I found quite problematic was even when courts find that the provocation defense does not apply. So basically the court said the accused person is not entitled to provocation defense. The courts still rely on gender stereotypes when discussing the provocation defense. So Singapore in 2019 adopted a whole raft of legislative amendments to the penal code, and it has actually codified the provocation defense test, which applied earlier on as a matter of common law. And its codification has actually a very strong gendered aspect. So based on Singapore's formulation of the objective test, now codified, courts may consider the age and the sex of the accused when assessing a person's level of self-control. So this kind of assumes that if your sex would affect your level of self-control. This gendered formulation has been argued by commentators to reflect stereotypical beliefs of women as the gentler sex and of men as normally active and aggressive, which actually favors men in terms of getting access to this defense. So in looking at some cases where even when provocation defense was found not to apply, judicial discussions of this defense and the facts in Singapore may replicate gender stereotypes. So in the case of public prosecutor versus Sarima Vijayan Govindasamy, the accused argued that he had been provoked by the behavior and the dressing of the victim, his soon-to-be ex-wife. The victim had gone out with her friends for drinks and was later found by the accused drunk at a bus stop. The accused dragged her to a nearby block of flats, assaulting her along the way and finally pushing her off the top floor. When questioned during the court process, the accused stated that the victim had been wearing a half bareback blouse with low-cut neckline in front, which was far too revealing for him, given that she had gone clubbing in that dressing and gotten drunk. The Singapore High Court found that the accused had not lost self-control, so he was not entitled to provocation defense. However, it held that the accused did not meet the objective test, as based on objective standards, the deceased was not dressed in a way that was so revealing that a reasonable person would have reacted in the same manner. The court went on to describe the deceased's attire. You know, she was wearing a pair of black pants, a sleeveless top, and she had a jacket belonging to her, which she would have worn when she was out drinking. So my critique of this case is, while the court found that the requirements for provocation was not met, its assessment of the victim's clothing unfortunately affirms that a woman's dressing could amount to provocation. So the language of some judicial decisions also give undue importance to whether the female victim demonstrated sufficient consideration and sensitivity to the accused when rejecting the accused in terms of trying to leave a relationship. So in Chan Chun Wai, the Singapore Court of Appeal held that the accused was not entitled to the provocation defense, but its discussion gives rise to some concerns, because on the day, the court noted that on the day of the killing, the accused was trying to reconcile with the victim, but informed him that no, she was interested in another, and her new boyfriend had better career prospects, upon which the accused strangled the victim to death. The court held that provocation did not apply, and highlighted that the victim had been quite sensitive to the accused's feelings by telling him several times that she was not suitable for him and that she hoped he would find someone better. The court went on to contrast the victim's conduct with the victim in an earlier case. It's a very famous case, Huan Chin Cheng. And the Chan Chun Wai court underscored that the victim in the earlier case had used insulting words, but and that the accused therefore was entitled to the provocation defense. However, the court failed to recognize that even in the earlier case, the victim had been subject to constant harassment of the accused and his deception before she resorted to such insulting words to just send him off. By juxtaposing the conduct of these victims, the court thus compared the callous conduct of the deceased in the later case to the sensitive conduct of the deceased in the earlier case. So my concern is that these stereotypes of proper female dress and behavior reinforce broader cultural and institutional arrangements in Singapore based on women's proper and subordinate position in society. So very quickly, I will now go on to say that apart from not relying on gender stereotypes, what should courts do? This particular positive obligation of courts have not been really addressed in jurisprudence or scholarship so far, even though there is a body of work, particularly that by Cook and Cusack, who argued that at the very least, courts should be engaging in the naming and critique of gender stereotypes. So one interesting case is the Malaysian case of Parameswaran. And this case is interesting because the High Court took a sensitive approach to analyzing the accused person's violent acts. So he had caught his wife. He had caught his wife sexually fantasizing, and she had confessed infidelity during the argument. But the court actually examined the intimidating tactics deployed by the accused towards the victim and argued that actually he had been in complete control of the situation. And this, even though the court did not articulate this actually shows a sensitivity towards the dynamics of domestic violence, which the accused person is not actually losing control. The accused person is seeking to control the behavior of the victim. However, the court did not go further to explain what was its rationale and what were the gender stereotypes and assumptions motivating the accused person and this entire crime, and it could have done so. So when I present my work, very often people will ask me, what are the good examples? And one good example that I can think of and that I elaborate on in my paper is actually from a Singapore court, which represented both victim and accused person in a dignified and respectful manner. Now this case actually, the case of Lim Ah Seng, actually concerned a female victim and a male accused, and the male accused was subject to long-standing violent and behavior from his wife, and he killed her in response. And the Singapore High Court actually recognized that, apart from recognizing the long-standing abuse, it took care to emphasize that none of what I have said should be taken as suggesting that the deceased's life was worth less than anyone else because she was an abusive spouse. So I think that's important when recognizing, when telling a story of what happened, that both accused persons and the victims are represented in a dignified manner. So my last point, which I will go through very quickly as I'm very conscious of my time, is that apart from naming and critiquing, and apart from representing accused and the victim in a respectful and dignified manner, thirdly, courts need to exercise their judicial interpretive discretionary powers to shape the law. So very quickly, there are some Indian cases whereby courts have said that conduct that's legitimate can never be provocative. So the fact that when a woman is demanding maintenance and she has initiated maintenance proceedings, the court has found that no way can that be treated as provocative. And in another case, the court said that it is very normal in marital life for wear and tear between the partners to take place. And so any altercation can never be deemed to be provocative in nature. And at that, I will bring my presentation to a close, and I look forward to the discussion. Thank you.
Thank you, Ling, for that very detailed and involved examination of these cases. I think it's really important, something that you've pointed to, which is that even seemingly innocuous of treatment of material can actually be gendered and be quite problematic. And it is important that we excavate the assumptions that we are making when we treat, in treating these materials, and to treat persons as not just caricatures of a gender. So for our next speaker, we have Marco Wan, who is currently Associate Professor of Law and Director of the Program in Law and Literary Studies in the University of Hong Kong. Marco's award-winning works examines the depictions of gender and sexuality in literature, law, and film. And today he'll be addressing women's rights and film censorship using Hong Kong as his anchor jurisdiction. Marco, on to you.
Thank you very much for the invitation to take part in this symposium. So I will approach the relationship between gender and public law by offering some reflections on the impact of censorship on representations of women in film. And so in a sense, my contribution shifts the focus from looking at gender in the law to looking at the impact of law on constructions of gender in popular culture. And I'll take as my case study what's known as the Category 3 film in Hong Kong. So this is taken from a longer project on film and law. And I'll begin by giving an overview of Category 3 film. And then I'll say a little bit about the film censorship regime in Hong Kong. And then I'll look at the interaction between film and censorship. So Category 3 films. So these are films that are restricted to viewers over the age of 18. And they are usually recognizable by the Category 3 sign, which is a triangle with a Roman 3 in the middle. And this is usually prominently displayed on the advertising material. This genre reached its heyday in the early 1990s in Hong Kong. And I have recollections of walking home from school and seeing the kind of ubiquitous posters of these films on my way back. And there are two things I want to emphasize about this genre. So first of all, these films were not pornography, right? So they were not banned, they were not restricted to porn shops, right? These were films that were shown in mainstream cinemas in Hong Kong. And it was not uncommon for actresses to move between Category 3 films and more mainstream films. So, you know, you could have an actress who begins her career in a Category 3 film, make a big name for herself, and then move on to family comedies, right? And that's happened. The other thing I want to emphasize is that this was an extremely misogynistic genre. And so, you know, we're talking not simply about sex and violence in the conventional sense, right? But really, we're talking about kind of lengthy sequences of women being raped, women tortured, women who are tied up and then chopped up into pieces, women whose bodies are dissolved in acid, right? This is kind of sick, depraved stuff that we're talking about. And as the film critic Paul Funneroff notes at the time in the early 1990s, he says, there's a PhD thesis waiting to be written on the subjects of what these films say about Hong Kong society. particularly the status of women and the popular perception of our legal system. And these films came into being after the colonial government implemented a censorship regime in the late 1980s. I mean, it did that through the Film Censorship Ordinance of 1988. And this was implemented as a result of a scandal. So what happened was the Asian Wall Street Journal, in an expose, revealed that the colonial government had been censoring films in Hong Kong for years, but without any legitimate legal basis for doing it. There were times when the films that were censored on the basis of the depictions of relations with China, right? So it was political censorship. And when this was revealed, there was an uproar in Hong Kong society. And that led to the implementation of the Film Censorship Ordinance so that the colonial government could give itself a legal basis for censoring. So what happens when you impose censorship? Nora Gilbert, in her book, Better Left Unsaid, which is about the Anglo-American experience, Gilbert in that book says that, you know, if you look at Anglo-American jurisdictions, what happens is that depictions of sex become subdued, right? So the sex becomes, or sexual relations become conveyed through innuendo, through subtext, through what she calls silences that speak louder than words. But in Hong Kong, the situation was the exact opposite, right? So not a few years after this censorship regime was imposed, there was this explosion of this highly graphic, highly misogynistic material. So, you know, I found myself wondering, you know, what is it that accounts for that difference between the Anglo-American experience and what happens in Hong Kong? And I think there are at least three factors at play here. So first of all, the Film Censorship Ordinance in Hong Kong was drafted in very vague and very broad terms. So when deciding whether a film would be censored completely or completely banned, or shown in a cinema with a Category 3 label, the censorship board looked at whether the film depicted cruelty, torture, violence, crime, horror, disability, sexuality, or indecent and offensive behavior. So what happened was, within this context of very broad, very vague terms, filmmakers started pushing the boundaries of the genre, right? And they started putting more and more sex and violence and crime and cruelty into the genre in order to figure out, right, how much of these things they could put in before a film would be completely banned, right? So their exploration of the contours of the genre, which was sparked by the vagueness of the terms in the ordinance, meant that a greater and greater amount of sexual violence and depravity went into these films, right? Paradox. The second factor is the commercial nature of Hong Kong cinema. So Hong Kong cinema in the early 1990s was dominated by low-budget commercial productions. So nowadays, people who think about Hong Kong cinema think about Wong Kar-wai, right? And Wong Kar-wai was already making films back then, but you know, he's very much the exception to the rule, right? Or he was at the time. And you know, in that period, filmmakers went for sensationalism. They went for titillation. They went for shock effect as a way of boosting sales, right? So as one prominent film critic noted, the Category 3 label functioned as a warning, but also as a temptation, and also as a dare to the audience to see how far a film would go in its depiction of taboo subjects. Right? So there was a real kind of unexpected seductive quality to that Category 3 label. And then the last factor I want to talk briefly about is that women's rights and gender equality norms were only slowly emerging in early 1990s Hong Kong. Right, so in a 1991 report, the Hong Kong Council of Women identified unequal treatment based on gender across multiple domains. the Sex Discrimination Ordinance was not passed until 1995, after a period of very vigorous debate. And CEDAW was not ratified until 1996. Right, so the category 3 genre provided this kind of unexpected forum for problematic depictions of gender and sexual relations, because these depictions appeared in a period when women's rights and equality norms were still in their infancy. So when thinking about the relationship between gender and public law, I think we want to pay attention to both international factors and local conditions, right? And in this instance, the local conditions include the influence of domestic legislation, the conditions of film production within a particular society, and the national or subnational cinematic traditions. I want to close this brief paper with a somewhat contrapuntal note on transgender cinema in Hong Kong as a way of kind of opening things up and providing another perspective on this question of gender. So transgender cinema, I think, is a genre whose time has come in Hong Kong. And when I say that, I'm thinking of films like Tracy by Jun Lee that came out in 2018. A Woman is a Woman by Macy Xun that also came out that year. And as I was watching these films, I was struck by their conservative representation of trans identity. And what I mean by that is, these films kind of depict the ultimate aspiration of trans subjects as this complete crossover into the new gender, right? So in many ways, I think these films entrench the gender binaries that are still operative in Hong Kong. And there is very little, if any, queer interrogation of gender norms and gender structures in Hong Kong society. To kind of allude to the schema that Ross gave us at the beginning of the conference. So, I suppose I belong more to the kind of postmodern strand of analysis, as you can probably tell from my language. So, looking at these films, I found myself wondering, why is it that these films have such a conservative construction of gender? And I think one possible reason is that these films appeared after transgender rights had become fairly firmly part of the public discourse. Right, so the key case here is the case of W.V. Registrar of Marriages, which is a 2013 case. And in that case, the Court of Final Appeal held that transgender subjects, post-operative transgender subjects, could marry in their new gender, right, under Article 37 of the Basic Law, which is the article that governs the right to marry, right? And I think that judgment really kind of puts forward and perpetuates a conservative construction of trans identity, which then got picked up and disseminated within public discourse. And these films are appearing as part of that public discourse in the wake of a case like W. So I'll stop there. I'm aware of I have 10 minutes. I'll stop there, and I look forward to the discussion.
Thank you, Marco. I think many of us in Singapore are quite familiar with these, or some of the actresses who are quite famous from these films. Not that we would have seen them, but they, as you mentioned, transitioned quite nicely into family comedy. So it's really fascinating to see the legal framework that goes to sort of shape how some of these films, category 3 films, have come about. And really, you've pointed out to something very important, which is the commercial aspect of these films that drive, and I suppose, the depictions that we see in film. Now, our last but not least speaker is Devin Joshi, who is currently Associate Professor of Political Science at the Singapore Management University. Devin has done extensive research into female participation in political processes across a range of Asian jurisdictions, and he employs social science methods to this inquiry. And today we're very pleased to have him here to share his research in female participation and how it feeds in, which is crucial because it feeds into how law is made across the region. So without further ado, Devin. I apologize, Devin, as you're switching on your video. I wanted to remind everyone that we are taking questions through the Q&A function. So please feel free to insert your questions in the Q&A function, which is at the bottom right corner of the Zoom webinar platform. Devin, on to you.
Okay, thank you, Jaclyn. Very nice. Thank you very much for that kind introduction, and thank you also to Maartje for inviting me to be on this distinguished panel. I'm very happy. I wish we could all be in the same physical space together, but at the very least, we don't have to all be in mask form like this. But in the world, many people do have to be masked up, and today, in these days, it's for safety and public health concerns, but in some cases, it is the law that one always has to be masked up. And so law can have a very intimate impact on our lives because of what it requires us to do, what it enables us to do, and the consequences that we face based on our actions or our failure to, or our resistance against following certain actions. What I'm going to do in this short amount of time is to just give a brief overview on the role of women's political representation in Asia. As you, I think most of it, how many of you are in Asia? Let's see, okay, it looks like almost all of you are. Okay, it looks like there's one person who's tapped into our Zoom who is not from the region. And Asia is, we are the world, so to speak. That was a song back from my era, we are the world. Asia is 3/5 of the world's population. And there's a considerable amount of diversity across the countries of Asia, and there's a considerable amount of diversity within Asia. And when it comes to women's political representation, there's a considerable amount of diversity as well. And what I'm going to do is I'm going to talk about 5 different elements or aspects of women's political representation. But first, before that, I'm going to talk about how women's and gender representation is part of what I would call a scary phenomena. And why am I saying is it scary? You're saying, oh God, the male participant at the end of the panel is saying that women's participation is scary. No, scary is an acronym to help you remember something that in political psychology we call social dominance theory. And social dominance theory is a framework or a way of looking at society that posits that different groups of people seek to dominate other groups of people. Okay, now let's all hope that these theorists are wrong. But it does seem that in the world we live in, we see certain forms of intergroup domination, leaving intragroup domination aside for the moment. And the basis on which we see these fits into the acronym of SCARE, or scared, or scarred. S standing for sex, C for class, A for age, R for race, and E, ethnicity. So we live in a world that is scarred and scared. So what I want you to keep in mind is that the gender representation or gender misrepresentation and underrepresentation and overrepresentation, which we see in politics, is intertwined with and interwoven with forms of dominance in society. So gender and sex are only one sort of aspect or element or category in multiple forms of domination that go on in the lawmaking process, in the law adjudicating process, and in the upstream or earlier processes of our cognition and our thoughts, which determine what we want to have happen in our world, in our lives. Okay, so now that I've mentioned that, I don't want you to be scared. The rest of the talk won't be scary. I'm just setting the stage here. And I'm doing that in part because in Rosalind's excellent introduction to this, this webinar, she mentioned 6 variants of feminism, and she ended with intersectional feminism. And now that we are in the sort of 3rd wave or 4th wave of feminist scholarship and activism, I'm sort of bringing the intersectional to the starting point, because I think that's appropriate, particularly in a seminar where we're looking at women's political representation in Asia, where the intersectional is so important, and maybe gets put down lower on the list in maybe in Western contexts. So they think the intersectional is very important. Okay, so I'm going to mention 5 aspects of gender and political representation. The first is what we call descriptive representation. This is a way of saying that, do the representatives, do they look, act, and feel like the people they are supposed to be representing? A very simplistic way of doing this is to look at the numbers. So among the representatives, let's say in Singapore, women make up about, I'm guessing about half the population, give or take a couple percentage points. We look at the Singapore Parliament. Are half of the members of Parliament, the MPs, are they women? Do you know the answer to that question, audience? Yes, you all know the answer to that question is yes. No, I'm kidding. The answer is no. Okay. So that's one aspect of descriptive representation, but it's obviously much more complicated because, as our previous speakers have alluded to, gender is itself a social construction. And so women can mean multiple things, men can mean multiple things, and there are transgendered individuals and a whole host of gender identities out there. Okay, so descriptive representation is about the composition of the representatives. What is their background? What is their gender, their sex, or other characteristics, class, age, race, and so on. The second type of representation is the substantive representation or substantive representation. This has to do with what do the representatives actually do after they're elected. Do they take the money and run? Do they listen to what what the lobbyists with a lot of money tell them to do, request them to do? Or do they stand up for particular constituencies or groups that may be marginalized? Do they stand up for women? And we would think that probably women would be more likely to stand up for women than men would be to stand up for women. And on the whole, that actually is true. But it's much more complicated than that, because some women who are representatives don't stand up for women, and some men do. So substantive representation is its own area worth studying and understanding. The third type of representation I'll talk about is symbolic representation. Because our understanding of things and our making sense of the reality happens through filters and a process of interpretation. And how we interpret reality has to do with the constructs and the concepts that are in our minds, but also that information and those images, as Marco mentioned in the last presentation, that we are exposed to. So media, for example, plays a big role in creating symbols or treating representatives as in symbolic fashion. Do they focus on their speeches, or do they focus on their babies? Do they focus on their heads and what their ideas are, or do they focus on their high-heeled shoes? So these kinds of symbolic representations are important in gender and political representation. The fourth type of political representation that I'll talk about is sustainability. So this is the era of sustainability, the Sustainable Development Goals, climate change. But sustainability does not only relate to the species, the pandas, and the other animals and habitats of the world. It also has to do with how long the duration is of people who are the decision makers, and how long are the things that they decide on in place. Women in politics, women in parliaments, do they stay for a long time and move up to the advanced positions, or do they come and go? Okay, so the fifth aspect, which I've already sort of briefly mentioned, is intersectional representation. And that has to do, or the intersectionality of representation, and that has to do with how do the various background characteristics and experiences of a person come together to make them a unique individual. Because we're all different. Even if we have an identical twin, we're not the same as our twin. And so intersectionality is a way of thinking about gender as fitting within a sort of broader sociological matrix of other attributes, including things like class, age, race and ethnicity, sexuality, and so on. All right, so that is a brief introduction to some of the conceptual ways of making sense of representation. I will start off by asking you a quick question, and maybe you can write this down on a piece of paper in your home or wherever you are. What are the two countries in Asia which have the highest percentage of their parliament members as women? Do you know the answer to this question? I'll give you 5 seconds to think about that. Okay, so the answer to that question is two countries that seem very different but also have a number of things in common. They're both islands. They have both experienced conflict, war, and been split apart from another territory or a country. They are both places that have gender quotas in place that require a certain percent or certain share of their parliament's members to be women. And they are both places that have a proportional representation electoral system. That means, for those of you who are not familiar, proportional representation means that each political party gets the seats in parliament based on the number of votes they get. So it's very simple. A political party that gets 40% of the votes gets 40% of the seats. 10% of the votes, 10% of the seats. Okay, now you've maybe had a chance to Google the answer. The correct answers are Taiwan and Timor-Leste, also known as East Timor. Taiwan is also known as the Republic of China. So these are two sovereign states, so to speak, that are actually, their sovereignty is fragile. Indonesia would like to take back East Timor. The People's Republic of China would like to take back the Taiwan Republic of China. But in these two states, women have been able to exceed what the United Nations calls the critical mass threshold. And the critical mass idea is a one that is highly debated, but it is the idea that if you have a certain number of a group or a certain share of a group belonging to a certain group identity, it then begins to change the group dynamics. And the UN has said back in 1995, when they had the big fourth World's Women's Conference in Beijing, in the Beijing Declaration and Platform for Action, they said that, well, about 30% is a critical mass. And so this 30% or 33%, about 1/3, should be the target for women's participation in decision-making in everything that matters, politically, economically, socially. So when it comes to a parliament, a Congress, a legislature, 1/3 or 30% roughly should be women. So Taiwan and East Timor have figured it out. And so I encourage all of you to go visit those places if you're not already there. And I know Wen-Chen's already there. And so, and you can learn a little bit about what they're doing to see if other parts of Asia will be able to catch up to them. And it does seem that when we look at other countries that have higher numbers of women in their parliaments, they are often in post-conflict societies. They had something terrible happen. They had a war. And then in the aftermath of that, in the process of trying to come to their senses and restabilize, they recognized that excluding important parts of the population just doesn't work. Because if important segments of the population are excluded, they may go back to war again. Okay, so in countries like Nepal, after their civil war, they instituted a gender quota, a 1/3 gender quota for the candidates. In countries like Afghanistan, they had it put in a gender quota after their civil war. And so the representation of women in those countries, Afghanistan, Nepal, Timor-Leste, is actually quite high, and much higher than the richest countries in Asia. We would think that the richest countries in Asia would be the ones with the most women representatives. The countries like Qatar, the United Arab Emirates, Japan, Singapore, regions like Hong Kong. But that is not always the case. So that's why women are present in parliament is obviously a complex thing, but it has to do with a number of factors. One of them is quotas. Another important factor is the political parties. Yes. And the research shows, and in fact, there's an article that I think is really good about this. I'll show you. It's called if you can see that, the uneven representation of women in Asian parliaments. I'm one of the authors of it. That's why I'm biased, and I think it's one of the better ones on this subject. But political parties make a huge difference in choosing who the candidates are. Voters only see the tip of the iceberg. Voters see the candidates that the parties put forth for them to choose from. But the parties are really the key players in choosing who the candidates will be. So which political party and how the political parties operate has a big effect on gender and on the gender of our political representatives. The research shows that the more political parties there are for voters to choose from, the more likely there's going to be a higher share of women. Why is that? It's because if one political party decides that we're going to be very patriarchal and we're going to exclude women, other parties can say, hey, we can get some more voters, more women voters at least, or more progressive voters, more gender equality conscious or oriented voters by having some women candidates. And then other parties, if there's a third or fourth party, can say, oh, wait, we need to compete with that party. And so there's more opening for women candidates. There are other factors that matter. The research shows that parties that are more to the left, on the left-right spectrum, have more women candidates. This is the case in Asia as well, but often not by a lot. Often it's only by a few percentage points more than the parties to the right. Another type of political party that often has the most women candidates and the most women representatives are what we call green parties. Did you know that? Green parties, we're thinking of the Green Party. That's like a shop. My daughter loves that shop. There's one at the Paya Lebar Quarter Mall near us. But the Green Party is also a label for environmentalist parties, which have sprung up in the last 20, 30 years. And they tend to believe that the domination of nature by men is very much similar to the way that women are dominated by men. And so this has been one of the vehicles for women to enter to increase their share of political representation. However, there are very few active Green parties in Asia, and most of them only have been able to get influence on the local level as opposed to the national level. Okay, so there are many other factors that matter, but I don't know how we are doing on time, because according to my clock, I think we're starting to go into the discussion section. So why don't I just leave it at there for now. And thank you for listening to me.
Thank you, Devin. Thank you for that sort of wide-ranging and informative talk on, and informing us about the two countries that are doing pretty well in terms of political participation. I must say I got the first, but not the second. So now we've come to the end of the remarks by the speakers, and this is the time for questions and answers. As a reminder, please use the Q&A function for your questions, and do try to state to whom the question is addressed, whether it's to a specific speaker or to the entire panel. Now, Maartje and I will be moderating this part of the Q&A, but what we will do is we will at times bundle questions together in order to ensure a more efficient Q&A for everyone. So perhaps let me, so all our speakers are here. Perhaps let me get to the first question. I think that there is some focus and some query about the Asian context. What is specific about the Asian context, and how can we advance gender equality within this context? And so Noah Lim, for instance, asked, do you think, I will open this up to the panel, do you think that concepts such as feminism face greater hurdles in being accepted within Asia because it appears to be a more Western concept and is consequently perceived more as an instance of Western encroachment into Asian values rather than as being seen as a universal good that everyone should strive to achieve? So this goes to the entire panel, but perhaps to make this rather a bit more orderly, we can start with, well, why don't we sort of go the other way? So Devin, Marco, Ling, Dipika, Wen-Chen, and then Ross. Devin, I know
Sure.
you spoke, but I'm going to put you on the spot immediately.
Absolutely. There's nothing Western about feminism. That's the short answer. Feminism is, as I mentioned, there's social dominance of all types. The poor not being satisfied with being poor, vis-a-vis the rich, the young being dissatisfied vis-a-vis the old for being subordinated. There's nothing Eastern, Western, Southern, Northern about that. And it's the same way with gender. Women wanting to have equality with men, recognizing the system of patriarchy and male dominance that is mostly kind of not visible in society, but its manifestations are everywhere. There's nothing Western about that. What I would recommend everyone is to read this book by Chimamanda Ngozi Adichie, who's a very well-known Nigerian author. It's called We Should All Be Feminists. And have all your male friends read this too. There's nothing, feminism is not about women or men, Eastern or Western. That's my answer.
So I think, in Hong Kong, it's interesting. So that kind of resistance has come up before. We had a debate quite a while ago now about whether women could inherit houses in some of the villages in Hong Kong. And the kind of weirdness of the jurisdictional setup was that the villages were governed by customary Chinese law. Right, so under customary Chinese law, women were not allowed to inherit, and at the end, the laws changed so that the women could inherit. And I think strategically, in terms of countering that kind of resistance, what we learned from that particular example was that it's a question of framing. Right, so when people say, "Oh, this is a Western construct," this is kind of cultural imperialism, what is most effective is to find local examples of injustice, right? So local women, some of these female villages coming out to say, "I do want to inherit, and this is the problem when I can't. What's going to happen to my children? What's going to happen to my daughters?" So I think that resistance is bound to come up in Asia. And I think it's important to think through the nature of the injustice through local examples and through kind of concrete instances on the ground.
Ling.
So I think that's a great question, Noah. And I think it's often presented as a Western theory and concept, but as highlighted already by our previous speakers, there are important feminist theories from Asia. And also, even if the concept originated from the West, and this itself has to be unpacked, I will argue that, like the language of human rights, it has been claimed, employed, and very often reshaped by activists and citizens in different Asian countries.
Dipika, would you like to comment on this question?
So, I think in the Indian context, I can speak for India. I think we've had a very long-standing women's movement in the country, and I think the post-colonial feminism context is actually a response to the Western ideas of feminism, especially in former colonies. I mean, in settlers and all of those contexts. So I think when we, I mean, there is no one kind of feminism. There are feminisms, and I think even in the Indian context right now, you actually are hegemonically struggling with different kind of feminisms and looking at multiple ways to think about different rights and different spectrums. I think having a women's movement which is very strong, for example, when the Western world was struggling with suffrage movement, India didn't actually do that, right? So in the 1920s and 30s. So I think the hegemonic discourse might be feminism, which is Western, but I don't think that's the application or the realization in the context of India. I think it's very much post-colonial and multiple other aspects, like Dalit feminism right now is really prominent, and criticizing the middle class Sarvana feminism. So I think we need to think of it in that context.
That's right. I think that advocacy has to happen at the local level as well, because that's where you really know what kind of problems need to be addressed. Wen-Chen, would you like to sort of comment on this point?
No, I agree with what's being said. I think feminism as a discourse, as a theory, may be Western, but sex and gender equality and dynamics are not. So they are definitely locally contextualized. When any woman, or queer or gay, lesbian, they go on street and go on court to assert their equal rights, that's definitely not Western at all.
Thank you. Ross.
I really agree with what Wen-Chen just said and everyone else as well. I suppose what my view would be, and this partly responds to another question that we will no doubt discuss from Alicia, is that ideals of gender equality are universal, and I think that Asian countries have embraced that, but how one presents and frames them needs to be particular to the context. And so, for instance, I don't think that there's any reason not to think that LGBTQI rights can succeed in Asia in the way that JMT's question sort of poses, but one needs to kind of pitch disruptive discourses in ways that are mindful of concerns about stability. So that means an emphasis on transformation, but also just how disruption is localized rather than systemic and not all encompassing, etc. So I think one needs to say that clearly it's a universal ideal that applies in Asia. Suggestions otherwise about human rights have been debunked in lots of very persuasive ways, including by this panel and others. But that one needs to frame arguments in ways that are sensitive to competing traditions, and those competing traditions can include, concerns about tradition or stability, and one needs to be strategic about how one thinks about framing arguments. There's a really interesting point from Dinesha to me about that. So one of the things that I'm doing, and some of the other work I'm doing at the moment on responsive judicial review and trying to kind of a mix of voice and weak, strong review that can be effective, is think about how you justify progressive outcomes, if you like, in discourses that resonate to those disappointed or uncertain about change. And that's a mix of the universal and the particular. And so if in a particular context there's a strongly nationalistic discourse, one can link one's goal of gender equality to a certain kind of historical memory. So it's going back, as you say, Dinesha, to a sort of colonial moment of women's leadership, or to a nationalistic discourse. So you can link feminism to nationalism in strategic ways. Now you have to be careful, like you may be ratifying a discourse that you don't want to do, but where you can, you need to have those sort of strategic alliances. So, for instance, Marty's lovely opening about the McKinsey report. One of the other things I, teach and write on sometimes is law and economics. I am very doubtful of some of those reports' validity, actually, but the narrative that Marty's weaving is one that brings in a certain Singaporean commitment and tradition, and weaving it with gender inequality in a way that is respectful to the traditions that she's operating in. So she might not be right about the merits of the McKinsey report, but she's performing respect for the competing and multiple traditions within Asian constitutionalism, which I think is very effective. So I think we need to recognise the universality of the commitments, including in Asia, but be strategic about how we frame and present them and what we ally them with, and how we sort of temper people's resistance by virtue of a willingness to adapt how we explain and justify our aims and how they fit with other commitments.
So thank you. This is really interesting because obviously we are not, we have to be very careful about sort of having a one-size-fits-all approach to advancing gender equality. But perhaps I could sort of follow up on Ross's sort of response to Dinesh's question for the benefit of the entire panel, because I do think that this intersects with some of the problems that we see in some jurisdictions, maybe not all of that. And this is about the question of how nationalism, and this can be nationalism as civic nationalism, it can be nationalism in terms of religious nationalism, and also ethnic nationalism, I would say. How does nationalism impact understandings of feminisms, and how could it sort of create obstacles, or perhaps it could be an opportunity for the advancement of gender justice, right? So in particular, we are seeing a rise of nationalism across the world, but in Asia, we are seeing this, we see this nationalism also arising in very religious or ethnic terms as well. So to the extent that there is an Asian sort of focus here, the question is how is nationalism intersecting with gender justice in different countries across Asia? So building on what Ross was saying as well. Perhaps we can start with Dipika.
Just very briefly, I wanted to say that I think just also piggybacking on the previous response on the Western, I think the rise of nationalism is actually, there is a lot of resistance from the feminist sort of movements in the country, obviously, because it's not like the right-wing government is not giving you the rights. In fact, sometimes they are giving you those rights to sort of bargain better in terms of the negotiation in holding these political positions. But I think there is a strong resistance. But I think every time there is a conflict, the right wing will actually make an argument against Western feminism, for example, in terms of censorship or in terms of dating culture. So those kind of arguments may come in from the right wing. But looking at how the nationalism responses, there is, at least in India, a very strong response from the feminist movement and strong resistance and protest when it comes to sort of a collusion between the two sort of domains.
That's very interesting, because I do see that oftentimes there is an instrumentalization of gender justice as well for to advance certain political purposes. I wonder if the other panelists would like to chime in on the question of nationalism and gender justice.
Okay, I would like to say something. So I think on the one hand, we see the rise of nationalism, but we cannot underestimate also the rise of transnationalism. And transnationalism can happen in different levels, right? As I said, transnationalism can be developed around judicial elite. So it's not a popular movement of transnationalism, but it can be a transnational circles of judicial elites in different areas of the countries, of the world, right? And so this bunch of judicial elite can work on a transnational scale to counterbalance the more popular base of nationalism occurring in different jurisdictions, right? So I don't suggest we see this as a very single dimension transnationalism, nationalism in single jurisdiction. I suggest that we see more complexities in different layers. So that's what I would join on this.
Yes, and of course we are familiar with sort of these global conversations that are going on, and your presentation really looked at that regional networks that also is taking place. Any other?
I would just add again the idea that there's these countervailing forces, as Wen-Chen says, transnational and national. But as Dipika says, we need to be quite mindful of the strategic response of gender justice advocates, both in the short and the long run. I always remember, you know, being at a conference, Law and Society conference, and this was my youth where I was much less pragmatic, thinking, but you can't say that. That's sort of, you know, it's totally inconsistent. And someone says, I don't care if it works. And I think that's got real health to it as an attitude, but it is dangerous, which is if you embrace nationalism today, well, tomorrow it might really harm you. And so you do have to have a short and a long run frame for the alliances that you want to form. And I think particularly around those sorts of discourses, one might be willing to use the discourse in some settings, but embracing the movement is a much deeper and more problematic decision that needs to be thought out very, very carefully. And I think the Indian example is probably the strongest one in that regard. Obviously, Dipika knows better than all of us about the nuances of that, but I would say the discourse and the movement are different in that context, but one also needs to think about both the short and the long run.
Thanks for that. Now, maybe then if we can follow up and transition almost from the movement to the law and the legal process and such. Some of the participants have asked whether you are of the view that there should be a greater recognition, legal recognition of gender. And here the question is not just whether that should happen, but also the form that this might have to take. So Dipika has already spoken about the importance of health and supporting structures. Devin has mentioned the idea of quota. And then one of our panelists has said that in the UK, there is a positive equality obligation for public institutions writ large. Is that something that we want and can see in Asia? So maybe, Devin, let's start with you since you brought up the point about quotas, and then we'll see who else can add to the discussion.
Oh, well, the short answer is yes. I mean, I think there's quite a lot of room within law for I mean, law is already extremely gendered, right? It's just a very masculinely and gendered and it has been for a long time, right? So it's not like a gender is anything new to law. It's just that it's just about reconstructing that genderization or the gendering of the law. But I think in the specifically Asian framework, you're talking about a combination of countries where some are more rule of law, whereas others are more rule by law, and others are more sort of just rule of man rather than rule of law or by law. So I think that the legal changes need to, there's a lot of scope for that. But it also has to do with the society as well. And the messages that are circulating in society, the discourse, as Rosalind mentioned very well, I think this is a process where the lawmaking process impacts the discourse, because the lawmakers choose who heads the ministries of education, the ministries of information and communications, that determine what messages are in the schools, in the media, that the religious authorities can preach and so on. At the same time, people at the more local level, I think this is a transcalar thing. It's not just international, transnational versus national and local. It's transcalar, and that, you know, I mean, as Adichie has, I'm going to plug this book again. They say people only remember 5%. So if this is the 5% you remember this thing. What is really key is the parenting, and for mothers to teach their sons not to be aggressive and to outcompete other people, but to be kind and considerate in everything they do, and to step back. I mean, just things like that. Of course, is long term, right? But that is needed as well, not just changing the letter of the law.
Okay, so you'd really say it's like it's a community, it's a cultural response. that inquire us to truly engage rather than wait for a law to be passed that might be symbolic at best. Now, Dipika, I saw you nodding at times quite vigorously as Devin was speaking. I'm sure that you have some points to add from the Indian experience on how law should deal with gender.
So I think the way we understand gender is not in the binary anymore. And India has actually progressed legally quite a bit on that. We've had a decision on transgender law in the country and recognition of trans rights in the country. And now we recently had a legislation, much to the dissatisfaction of the trans movement in the country, but the legislation is there, which recognizes certain rights also, but violates certain other rights. So I don't know if recognition, if law by itself is emancipatory, because there are like very oppressive institutions. For example, school, because Devin was talking about school, and I think I was nodding on that just because I have a 4 or 5 year old, and I experience this kind of institutional discrimination every day. So it's really so when we're looking at an institutional sort of way on how this law will operate, it is very difficult. But I think the recognition is very important, and we've seen that in the country and how the recognition has been so important to even have a trans movement sort of navigate their way through negotiation, through resistance, through protest culture. And it's a very organic movement that has a very sort of, it's trans-led organic movement. And I think somewhere the Supreme Court decision did pave the way for that kind of legitimacy. So I think that's important. But having said that, I think there are two ways to look at it. One is to look at whether we want to make a sort of a conceptual difference between sex and gender, and then look at those differences and then think about the two, which can be different. Or do we look at constitutions where the recognition is only sex, and then that has been interpreted to mean gender, or in the Indian context, sex has been interpreted to mean sexual orientation. So I think the interpretation can also widely vary, and it may not always translate into sort of emancipation for the community that one is engaging with. So I think there are multiple factors here, and multiple approaches and multi-pronged approaches are very important. And law by itself cannot actually be emancipatory, but it can be the first step for certain kind of recognitions.
Thank you for pointing out that this is a nuanced and it's a complex question where this black and white answer, we've passed a law and by now all is well and women will be recalibrated, that clearly is not going to happen. So I think here it might be interesting to turn to Wen-Chen, because Taiwan is a case where the law has been changed in response to gender litigation. What are your thoughts on this? Has it actually made much of a societal impact?
I do want to join on this dialogue. I think law and society have a very complex relationship in promoting sex and gender equality, right? We often saw that social change would have brought legal change. But in the way that I introduced you recent developments in Taiwan, you can see that legal change first, right? So the Taiwan Constitutional Court recognized gender equality that was not written in the Constitution, right? And then they receive that kind of a social discourse, and then also reflecting upon the social movements, right? And again, adultery case, right? Again, law represented by courts is really ahead of society, right? And so law plays that kind of generative function for social change, right? And definitely they are also going to meet with social resistance. But I think this is also ironically and paradoxically in the way law is also in the sense patriarchal in bringing social change, right? And so law is giving the space in which society reacts, right? So I think this is interesting. And also in response to Devin, right? In the sense, you also see why Taiwan moved up to this #1 country in Asia where women politicians, women representatives occupy the most of the parliamentary seat, because we have the quota first, right? So I don't want to really say that in the area of sex and gender equality, we need the law first, right? In the sense we need the legal patriarchy first in order to open up the space. Whether this will be the Asian way, whether this will be a kind of a strategy that Ross has been talking about, I'm not sure. But I think it's also interesting to see this particular pattern in which in Asia, where judicial elites, where law plays the kind of leading role in bringing about social change in relation to sex and gender equality. But then, of course, I will be cautioned. There is this patriarchy. There is this power relations in this.
And here, supposedly, that women might be constrained or conditioned in a way by these existing structures rather than be liberated at the same time. Now, perhaps on that note, if we follow up with the idea of stereotypes, which has come up in some of the questions as well. So, Chiao, Ling, you've spoken quite a bit about stereotypes in the courts. And I think the underlying question we need to confront is, how will judges identify these stereotypes? How will they be aware that these exist and may need to be confronted? So almost linked to that, and that's something else that Dinesha asked in her question, to what extent are the current stereotypes a product of the colonization process? Whereas if we would go back to pre-colonial times, we might have seen a very different role for women in at least some of the Asian societies. So Ling, perhaps we can start with you, and then the rest, do please chime in.
I think that is in the scholarship on gender stereotypes, most commentators recognize that it is very difficult to identify operative gender stereotypes because stereotypes can be explicitly subscribed to, but there's also or implicitly held. And when you talk about implicit bias or implicit stereotypes, the person holding these stereotypes may not be aware that he or she subscribes to them. And it's only through very sophisticated social science studies that sociologists are increasingly able to identify operation of implicit bias and implicit stereotypes being held by decision makers, including judges. So that is still an evolving field. And I think that in terms of judiciary and other state actors, it would be useful if they kept abreast of such developments, research developments. And there's the importance of continuing training and education. Even though, interestingly, social studies show that training and education is seldom the most effective way of dealing with stereotypes. That actually exposure and increased connections with people from different backgrounds, that is actually a better way of undermining stereotypes.
Which might always bring us back to the point again on quotas, right? As long as we make sure that we have different constituencies or individuals in the same room, they will have no choice but to muddle their way through and find a way to get along. Marco, I see Rosa's hand. I will get to you in a second. Marco, I'm sure you have something to add on the question of stereotypes, deconstruction, and perhaps the impact of colonialism.
Yeah, so I mean, I think, on the question of cultural stereotypes, I mean, I do think, the media plays an important part, and Devin alluded to that too. On this question of quotas, and to echo what you were just saying, I do think that in Asia, this is, I'm trying to articulate the relationship between quotas and stereotypes. I do think in Asia there is not enough of a discussion about quotas in relation to what, right? So there's a question of quotas and gender, and I think implementing these quotas has had an important and positive effect. But I think sooner or later the question of quotas in relation to sexual minorities, that's going to come up. Quotas in relation to people with disability, that's going to come up. And I think, to echo your point, as you expand the realm of representations on boards, on committees, through these quotas, that's going to have an impact on stereotyping, right? That it's going to, that expanding that realm of representation is going to dispel some of these stereotypes that circulate in different domains. But I do feel like we're not having enough of a discussion on that in Asia at the moment. So there's very little discussion of representation of gays and lesbians on committees and boards, for example.
Absolutely. And I think here, just before I turn over to Ross, this is not only something that we see in, if you want, the public domain, this is also very prevalent within the private sphere. So if we look at businesses, the representation of the non-male and other dominant characteristics individuals is really far and few between. And perhaps here we again also bring the issue of intersectionality up. How would we ask these others who are not currently represented in large enough numbers, what constituency would they need to identify with? Now, Ross, I saw your hand as well on the question of stereotypes. Over to you.
I'm just trying to mute something. So I wanted to just come in picking up on some of the other comments. One is about the history and, can we go back to a earlier time? I think there's always resources in our histories that we can archive and use, but I think we shouldn't romanticize. Gender equality is for the most part on an upward trajectory. And so to kind of romanticize the past, I think, is a danger, but to mine our own history and traditions for a more egalitarian moment is also very useful. I always think on stereotypes, it is worth remembering that there's a normative evaluative aspect to them. A stereotype is a normatively problematic overgeneralization, and I think we often think that they're an empirical question. What is a stereotype? Well, no, we make generalizations all the time. It's only when it's normatively problematic that it becomes a stereotype. And so I think we need to retain the normativity in that question of how do we tell stereotypes. And then the only other comment I wanted to make, just is again drawing some of these themes together, was from Weiling's comment about, multi-pronged strategies or versus, one or the other. And there's some interesting comments in the Q&A about this. I think the story we need to tell globally is that you have to achieve this through many paths. So you need a legislative path, a judicial path, an education path, a social movement path, a consciousness raising, and they have to all go together. And so then it's less able to be picked off and said, well, we're having kind of educative mediation models as an alternative to litigation legislation. You don't want to buy into a strategy that says you can have some part of it. And so I think when we tell these stories comparatively, we need to emphasize the many moving parts, the multi-institutional story. And, I love Devin's story about parenting. If you're interested in that, you've got to read Nancy Chodorov. It's the best, most interesting post-structural, postmodern account. But we have to do all of it. And we shouldn't ever present one thing as like, oh, it's legislation. Oh no, it's mediation. It's all of it. And the most successful stories like Taiwan iterate, one builds on the other, and it creates this amazing jurisgenerative politics that's very powerful. But one needs to tell a story, I think, especially in Asia, that emphasizes the multi-pronged nature of change generally, but especially for gender.
So this is fascinating, but if we sort of, with little time left that we have, I wanted to sort of maybe move towards what do we do going forward, right? What kind of strategies should, gender justice advocates should sort of have in mind in trying to improve gender equality contextually, but yet with a nod to sort of these universal ideas of equality. And so I wonder if we could sort of have some of your thoughts on how to balance strategic engagement with sort of a more, if you like, aspirational type approach to advancing gender equality. And I ask sort of maybe perhaps from a perspective of, let's say, we do see in certain countries a focus on gender justice as a matter, as an instrumental matter, as a way to advance economic interests. So what I saw in a recent paper for Wen-Chen called economic pragmatism. But at the same time, you do see that when gender justice is being advanced as a secondary aim to economic aims, for instance, it can end up perpetuating some of the pre-existing patriarchal ideas about, gendered work and so on. So in the little time that we have left, I wanted to sort of hand it over to all of you to sort of what are sort of some of these strategies that we can adopt to advance gender justice in your particular context. And perhaps you could sort of identify one or two sort of pressing issues that we will have that you think we should address. And let me just sort of go in the reverse order again, and start with Devin.
Okay, I'll just say three really quick things. First is our consciousness. I think that certainly gender quotas are here to stay. They're on the rise, and they are in many ways the futures. And it's not only gender quotas; it's about the inclusion of other marginalized, previously, currently underrepresented groups, and about having ceiling quotas for overrepresented groups. That's more important actually, probably, than having a floor quotas for underrepresented groups. So if we want to have a gender quota, just say no more than 50% or 60 or whatever percent men, and then you've already got you're going to bring in more women. Related to that is intersectionality. If you did that today in most countries, you would get you would increase the number of women, and they'd all be relatives of those men who were kicked out by the introduction of the quota. So many of the women who are the lawmakers now are from the same backgrounds as some of the men, except they're just women. So they're from the same families, they're from middle and upper class, they're from the dominant ethnicity, they're heterosexual, and you can go on and on through the list, right? So you have to think about the intersectionality. And then the last point is that we already basically have quotas, and it's just hidden. When it comes to the corporate board, when it comes to the courts, the Supreme Courts, all these things, there's already a quota, and people just don't realize it. And so if we become more conscious of this fact that there's already a hidden quota that it's got to be 95% male, or it's got to be all men who went to the leading university or have their degrees in certain fields, then we become more aware of that we're already operating under quotas. So the question is which quota? And then related to that is that it never stops. The inequality never stops. So you can have a Supreme Court with 3 judges, or let's say there's 9 judges. And let's say there's 6 men and 3 women. The inequality will continue there, and it may be on a gender basis or maybe a class basis, but you would actually need to have quotas all the way through in terms of talk time and so on. So that even in that small group setting, in order to really even things out. Most people probably don't want to even things out, but that's just something to be aware of. Thank you.
Well, that's very interesting, considering that the late Ruth Bader Ginsburg is famous for saying that, we will have gender equality when we have 9 justices on the Supreme Court and not just half of them, 4 or 5, whichever you go with that. So that's fascinating as well to see that actually quotas don't necessarily go far enough either. Marco, what do you think would be like your top 3?
My top 3. Well, actually, I only have 1, so I'll give you my top 1, which is, I think, strategically, there is something to be said about not framing the goals in too radical a way. And I say that because I saw that there was a question about queer theory. And I personally find queer theory hugely powerful. But there is a very radical dimension to queer theory. If you throw queer theory at the courts, right, when you litigate, you will never get anywhere. And you mentioned Ruth Bader Ginsburg, and my understanding is that that was part of her strategy as well in her when she was litigating, right? That you want to emphasize the importance of gender equality, at that time for men, right? And so there is, I think, it is important to think about moving, I suppose it's very common law of me to say, but incrementally and working with the constraints rather than seeking to leap too far ahead.
Thank you. Wei-Ling.
So just to repeat, it's the wish list. Am I right?
Yeah. Your
okay.
Or your top strategies.
I think that I think it will have to come from the top also. So I think that, and I have this conversation with Jaclyn before. There's a lot of talk about how those from underrepresented groups like women have to put ourselves forward, and we have to do more. We have to lean in, do more. I think that yeah, we all have to. Yeah, some of us are trying already, but I think that leadership can play a big role, and because there are many structural issues that those in power are able to take to make the process easier. So I think having leaders that are committed to this is really important, and also who don't think that feminism is a bad word. So I talk to students, and a lot of them say that feminism is still seen as a bad word. It's not nice to be known as a feminist. And I think that we really need to reclaim and educate everyone about what this word and what this thinking actually means.
So I think that this goes to the sort of multi-pronged approach point that I think Ross also raised, right? Because it's not just sort of in different aspects, but also sort of top down, down up, bottom up kind of like collaborations need to be happening as well. Dipika.
I think that women and trans persons experience oppression in different ways and in multiple ways. And I think it's really important to center multiple voices than have one or two dominating voices. And I think it starts with legal education. As an educationist, I know that your legal curriculum is catering to certain kind of production of technocrats. So I think it's really important to ask those questions. How much of gender, class, caste is there in your classrooms? And also, who is studying these things? Is it only the privileged group that is studying that? Because then we're going to replicate that for our bar and the bench. So I think the diversity has to start there. And then as we move forward to the bar and the bench, and we have to encourage diversity there as well, in terms of both perspective and nuances. And finally, something that I've been working on, and right now I'm working with the movement, is on the legislative aspects, right? Where you draft laws without any consultation. We don't have a pre-legislative consultation process in India. Without any consultation with the marginalized groups, for example, you can have a trans law, but if you don't consult them and if you don't take their concerns into consideration, it's not going to happen. So I think the centering of expertise and voices has to be reimagined. And that's when we can think about gender, and gender by itself is not sufficient. We'll have to look at the intersectionalities of class, caste, especially in the Indian context, and also indigeneity, which is really important.
Thank you. And Wen-Chen.
I think multiple strategies are the future, right? As I said, so sometimes even the elites model may be at work. And I think also to echo Marco, right? Gender quota is limiting, but sometimes I think it's also empowering, right? In Taiwan, when we have women on different levels of parliament, you start to see also lesbians, right? So once they are in the parliament, then they come up as open lesbian. Then you see the kind of generative empowering effect of those. So I think we should all try different multiple strategies.
And Ross, thank you, Wen-Chen. And Ross, I think that this sort of brings us nicely to where we started when we talked about disruption and transformative law, constitutionalism, and so on. So on to you.
Well, I think the one thing I would say about that is that one of the interesting questions about leadership, so LGBTQI, female leadership, is that act itself can be disruptive. Having people in visible roles is an important disruptive act. But sometimes we sort of load on to those people expectations of amelioration and transformation that they individually won't bear or can't bear. And so I think it's very important for us to hold on to the disruptive and inspirational potential of individual leadership, but also have an appropriately structural approach. So really not just in the lean in versus structure sense, but also not assume that individual members of a group are necessarily going to be the advocates who transform and or ameliorate. So I think we push for both, as you say, Wen-Chen, sort of, I think, echoing me, a multi-pronged strategy where visible leadership and change is itself a great achievement, but it's no substitute for a more substantive account. I wrote a piece a number of years back about, sometimes we might prefer male identifying Supreme Court Justice in the US who is progressive than a conservative woman if you care about reproductive rights. Now, ideally you want both, right? But I don't think we should lose sight of the benefits of visible diversity in leadership, but nor should we conflate it with, by itself, creating transformation or amelioration. Because sometimes to get to the top, especially in conservative contexts, you have to forego more radical political commitments of an ameliorative, transformative kind. So we have to have a multi-pronged approach, not just when it comes to the broad canvas, but within our institutions, and not assume that individuals who visibly represent us necessarily represent our broader political goals and commitments in terms of transformation and amelioration. It doesn't mean we shouldn't embrace them and support them, but it means we have to have a multi-pronged approach where we don't rely on them solely to achieve the broader goals of amelioration, transformation, and disruption.
Thank you. And so we must not hang our flag on just one pole, but multiple poles. So it is now time, unfortunately, to draw this symposium to a close. We promised all our speakers that they will be able to go for lunch. And all of you too. So firstly, we would like to, before we go, we'd like to express our sincere appreciation to the institutions that have made today's event possible. The International Society for Public Law, at the global level have shown their support. Thank you in particular to Ross. We would also like to thank the School of Law at the Singapore Management University, the National University of Singapore's Faculty of Law, and the Center for Asian Legal Studies. A special word of thanks to our administrators who make this possible, working behind the scenes, specifically Alvin Chi from SMU, Fina Wong, and Suguna Jagannathan from NUS Faculty of Law.
And then, of course, we also like to acknowledge the very warm support of the members of the advisory board of the Singapore chapter of ICONS. And last, but certainly not least, please join Jaclyn and me in virtually thanking our speakers, whose combined observations will have shed more light in how to think about and, most importantly, address a topic that looks to be in the limelight for many years to come. So thank you all once again for joining us today, and goodbye from Singapore.